All right, good morning, good morning, good morning. It is November 2nd, and we are here with Shaneka Shaw Taylor. Before we begin, normal caveats apply. First off, this is a private channel, the Ontario Facebook group, but our YouTube videos are public. Anything you say, my standard joke, can and will be used against you in the court of law. And just be aware of it because it will be posted on a variety of public forums. Secondly, invite your friends to join because, quite frankly, our group is awesome. And the more people who join it, the more awesome it becomes. So thank you all for being a vibrant part of everything. Of course, part of what our group does is bring relevant topics to the fore. And to that end, we have today's speaker, Shaneka. I am thrilled to actually introduce Shaneka because I have met her in the most genuine of ways. I have met Shaneka through performance. There's a lot of people who function in the real estate space, many of whom claim to do X, Y, Z. You always hear those claims, and this exists as much in the realtor space as it does in the legal space. But there are a few people who actually, through their sheer performance through their sheer competence, stand out. Shaneka is one of those people. I've come to know Shaneka as a dependable litigator who understands her craft and her field, and I have turned to her quite a few times in instances of breach, which is happening ever more regularly in today's world. So, without further ado, I'm going to turn it over to Shaneka, who is, I understand, also an agent as well, but obviously has been performing as a lawyer for the better part of many, many years. And Shaneka, please feel free to introduce yourself if I haven't done you justice, and hit it off. We are all excited to hear what you have to say about breach and what it's like being a litigator going through breach, and perhaps giving us some of the tips and details that you want the people of this channel to know.
Absolutely. Thank you, Mark. And good morning and welcome, everyone. As Mark mentioned, my name is Shaneka Shaw Taylor. I'm a litigation lawyer. I'm also a realtor. So I've been a lawyer for over a decade, practicing exclusively in litigation. And today we're going to be talking about dealing with default tales from the litigation trenches. And real estate, as you all know, is a very cyclical market. And right now we are in a period of time where the market is a bit depressed. Buyers and sellers are having difficulty honoring their obligations, having difficulty closing transactions. And that has made my life quite busy in the past few weeks and months. And I recently, just a bit background of myself. So as I said, I've been practicing for over a decade in litigation. I was a partner at a medium-sized firm for over 6 years and recently branched out to start my own practice, Taylor Litigation Professional Corporation, which is quite fortuitous that I decided to do this right now because the stars aligned with the market being as it is. And now I have so much work, I don't know what to do with myself, right? But as I said, real estate is a cyclical market and hopefully good times will be just around the corner. So at Taylor Litigation, we engage in strategic, timely, and customized dispute resolution mechanisms for our clients. We focus on 3 main areas: commercial disputes, real property disputes, and product liability claims. And we leverage our expertise and experience to provide tailored solutions in those areas. I always tell my clients that no 2 cases are the same. Every case turns on the facts. And that is so true when you are in litigation, because yes, you will read court decisions and you will say, well, the court decided this way in that case, so that must be how they will decide in my case. And that's not necessarily always the case, because every case turns on the specific facts in that case and how the law will apply to the facts in that particular case. Okay. So today we're going to be talking about breaches in the context of contract law in real estate. And what is a breach? Simply put, it's the non-performance of a contract in any way and to any degree, whether intentional or not intentional. And there are different types of breaches, and different breaches have different effect. And I apologize, before we go forward, I'll say that if anyone has any questions, please feel free to put them in the chat. We'll get to them at the end. I promise there will be ample time to answer questions. If you do have questions, I ask that you'll be, high level questions, not necessarily geared towards a specific case or seeking legal advice on a specific case. Because as Mark gave the disclaimer, we're not here to give legal advice, we're here to give legal education. So if you need legal advice on any specific instance that you may find yourself in or your client may find themselves in, please feel free to reach out to myself. I know there are other great litigators in the group, Greg, Wesley, Avi. Reach out to any one of us and we can happily help you. Okay. So as I said, there are different types of breaches, and different breaches trigger different effects. The two types of breaches that are primarily found in real estate cases are anticipatory breach and fundamental breach. And an anticipatory breach is when a party disavows a contract in advance of performing that contract. What does that mean? So generally speaking, it means when one of the parties to the contract advises before closing that they won't close the deal. And a typical example of that is when a buyer reaches out before closing to say, I can't close on closing date because I can't get funds, or because something's wrong with the property, or whatever reason they provide, if they provide a reason at all. And that type of breach, which happens before closing, we usually call repudiation. And I'm going to ask if you can mute. If everyone can just put themselves on mute, or if Mark or Sandy can do that, that would be helpful.
Yeah, I'll take care of it.
Perfect. So that's the first type of breach, anticipatory breach. And then the second type of breach, which is both a timing and a type of breach, is called a fundamental breach. And this is the failure to perform an essential obligation of the contract when performance becomes due. And that obligation goes to the very heart of the contract. So example, not closing on closing day. So in this, how this differs from the first breach is that the buyer waits until closing to say, I can't close today. And again, they may provide a reason, they may not provide a reason, but they, first notice of their inability to close is on closing day. And as I said, how the breach is treated in law depends on the type of breach, when the breach took place, and it also depends on what contractual term is not being honored. So for example, if it's a warranty versus a condition, how the breach is dealt with in law is different. And as you guys know, a condition is a fundamental term that goes to the root of the contract. The typical condition could be, this agreement is conditional upon financing or conditional upon inspection, or the agreement is conditional upon the seller doing a certain thing in order for the buyer to close. Could be getting site plan approval, getting some sort of consent from the municipality, whatever that condition is. If that condition isn't fulfilled at the time of closing, then that could go to the heart of the contract. And depending on who had the condition and who was responsible for fulfilling that condition, it will allow the other party to do either one of two things, either to treat the agreement as at an end and accept the other side's non-performance and say, fine, we'll walk away, and each party just bears their losses. Or the innocent party could say, no, I am holding you to this condition, and I either need you to put me in the position I was before the contract was entered into, or make me whole for damages. That differs from a warranty. A warranty is a promise, if you will, that a certain thing will happen after closing. So the typical warranty could be, you give a warranty as to the use and usefulness of an appliance, for example, or you give a warranty that certain things about the property are true as of the closing date or before the closing date, and they will continue to be true after closing. If that warranty or if that promise turns out to be incorrect, the innocent party doesn't have the ability to cancel the contract, but they have the ability to sue for damages. So a breach of a warranty doesn't allow an innocent party to get out of the contract in the way that a breach of a condition may, but it allows them to sue for damages after closing. Okay? And then, as I mentioned before, the timing of the breach will depend on how the court treats what happens to the innocent party. And so how do litigators like myself get involved in files? So I did some research on, the types of cases that are being litigated in recent months. And I wasn't surprised to find that they are the types of cases that, you see in everyday, in the group discussion every day. And I've tried to rank them in what I see more often. And the first is the buyer being unable to close due to lack of financing. And that's usually appraisal related. As you guys know, with the interest rate hikes, it's become more difficult for some buyers to qualify for financing. And they've either gone ahead and made firm agreements to purchase and sale, or they've prematurely waived their financing condition because, they either ran out of time or there was some false assurance that, yes, you will get financing, but didn't go through the actual financing process to make sure that their financing was in place. So those are, I'd say, the top cases that we're dealing with right now is, the buyer being unable to close because they couldn't get sufficient financing. And in one recent case, the Zaletta case, the buyer tried to make a creative argument of, well, because I'm not able to close or get the financing necessary to close, seller, you should give me an abatement or a reduction in the purchase price because, what I agreed to buy it from you for is not the true market value based on this appraisal. And, we see buyers trying to do that in many cases. And the law essentially says, the bargain that you struck is the bargain that you struck. If you agree to buy a property for a certain price and it doesn't appraise at that price, well, that's too bad for you. That's the bargain you struck. And so a seller is not obligated to reduce the price just because you can't get the financing, just because you, the buyer, cannot get the financing to close on that property. And then the second type of cases that we're seeing a lot of is sellers, and ties back to the first type of case, is sellers seeking shortfall in having to resell their properties at a lower price. So usually in the first case, it's the buyer that is bringing the claim to say, the property, I had a bad bargain because the property isn't worth what the seller tried to sell it to me. And then they're more likely than not, the sellers bring in claims to say, I had to resell this property at a lower price. Therefore, I want the difference in purchase price in damages from the original buyer. And usually, I'd say 8 or 9 out of 10 cases, the sellers will be successful in those claims. And not only are they able to recover the difference in purchase price, but if they have any additional costs that are directly tied to the transaction, such as additional carrying costs, additional tax payments, any additional costs that they had to bear as a result of the buyer not closing on the closing date, then they're generally able to recover those costs as well. And the third type of case that we see is buyers not closing because they're unable to sell their own homes. And in the market that we recently had, where we had all these bidding wars and buyers weren't putting in conditions in their agreements, behind the scenes, we would know that sometimes a buyer would often be a seller who had to sell their own home in order to buy this new property. But because the market was how it was, and agents or sellers, buyers themselves were trying to put themselves in the most attractive position as possible, they wouldn't put in conditions to protect themselves. And the condition that they would not put in is, well, the buyer has to sell their own property by X date in order to proceed with this transaction. So they, in their own minds, would say, okay, well, I'm going to buy this property anyways and still put my property in the market and hope that the stars align, everything aligns in terms of timing, and I can close on my sale and have the funds to buy the next property. But then sometimes the stars don't align. And what you have are cases where a buyer can't close because their property hasn't sold. And again, a creative argument that a buyer will try to use is, well, we weren't able to sell our home, so we couldn't purchase your property, therefore we shouldn't be held to the contract. But if you don't have the condition in your agreement, then you can't rely on that argument. And it's interesting to me how some of the arguments that buyers and sellers will make in their claims, because sometimes I'm reading these decisions and I'm like, well, why would you ever think that's going to fly? But people do it. So the fourth type of cases that I'm seeing a lot of is buyers failing to provide deposits when the deposits are due. And that's generally when, the buyer enters into agreement of purchase and sale, whether it's conditional or not. And most times if it goes to court, it's because the agreement wasn't conditional. So it was a firm agreement. And the buyer says, okay, I'll provide this deposit upon acceptance or within 24 hours. And then they have cold feet or they change their minds. And so the seller can bring a claim against that buyer for that deposit not being provided, particularly if the deal was a firm deal. And what the courts have held is that the failure to provide a deposit within the time frame doesn't mean the agreement died, because that deposit can be and should be treated as a debt owed by the buyer to the seller. And then the fifth type of cases that we're seeing a lot of is forfeiting deposits that have been paid by the buyer in transactions, either where there's a shortfall in the price that the seller had to obtain from another transaction, or even when the seller sells the property at a higher price than what it sold the property for to the original buyer. And then the last type of cases that we're seeing quite a bit of is partition and sale applications. And so that's usually where you have more than one owner of a property, and one owner wants out of the transaction, out of ownership, and the other property owner still wants to keep the property for whatever reason. And so the law imputes a presumption that an owner of a property is able to sell that property if that person wants out. And there are ways and exceptions of getting out of having the property sold, but it's a very high bar to meet. But we're seeing a lot of those cases as well. So those are the 6 types of cases that we're seeing a lot of as litigators in this space. So what can you do as realtors to protect yourselves and your clients from these types of lawsuits? So the first thing is due diligence. Before, in this market where, we are seeing that buyers are a bit more hesitant it's harder to get financing. There really is no reason why we shouldn't be making use of the conditions that are available to us for, especially on behalf of buyers. But before that, making sure that your buyer is pre-approved. Getting that pre-approval letter, reviewing that pre-approval letter, confirming the taxes from source documents and not just relying on what the seller is telling you in terms of taxes, reviewing available municipal documents to make sure that the necessary permits are available, or just reviewing the file to see if there are any issues that could arise in the future. Verifying measurements. I see time and time again, listing agents will put on their listings, buyer and buyer's agent to verify measurements. Yes, you can put that on your listing, but it doesn't prevent you, or doesn't absolve you, I should say, of the obligation as a professional to ensure that you're providing the highest standard of service to your client and verifying the measurements. There are services out there where you can pay a small fee to get a floor plan done, right? So there's really very little excuse as professionals as to why certain information shouldn't be verified. And the second thing I would say is have your clauses that you are intending to rely on in your agreement drafted and updated by your broker of record, and if feasible, reviewed by your client's lawyer, right? I don't think there is enough training given to realtors about the types of clauses that are available to them, the types of clauses that are beneficial in a particular deal. So I'd say, if possible, run it through the client's lawyer, or have the client run it through their lawyer to make sure that everything makes sense, and make sure that the client understands what the clauses mean. The next point, make sure you're reviewing the various clauses with your client. Time and time again, I have clients come into my office who say, the agent just sent me the agreement via DocuSign or AuthentiSign and just asked me to sign it. I didn't read it. I didn't understand that there wasn't a conditional clause in there to protect me. I didn't understand what I was signing. I just trusted my agent, and now I'm in a pickle. So make sure that you're reviewing the various clauses with your client. Go through with the client what their goals are, what the risks associated with each clause is, and get a sense of what they're trying to accomplish. And as you're preparing these clauses, think of, well, how can I limit my buyer or my seller's liability exposure? How can I protect my seller or buyer if they may suffer any losses? And are there certain things that need to happen either before or after this agreement comes into effect? And how can I protect my client in that instance? In this market that we're in, I personally think, and again, it's a personal opinion, that there is no reason why we shouldn't be including conditions to protect our clients. Conditions mainly on financing, inspection if necessary. And there's no reason, in my opinion, why we shouldn't be having reps and warranties in our respective agreements. Obviously, there's going to be back and forth in negotiations. The seller may not want to give certain reps and warranties, and the buyer may, but you can usually come to a middle ground with those clauses. And the next thing I'd say is document all advice that you provide to your client and all instructions that you receive from your client. Just as lawyers, we do this all the time, and we always emphasize document, document, document. Put everything in writing. And that's not only to protect yourselves as agents, but to protect your clients and to make sure that everyone knows and understands what they are agreeing to. Okay? So, what not to do when there's trouble on the horizon. Please, unless you are a qualified lawyer in Ontario with experience in real estate, do not give legal opinion. I know it goes without saying, but sometimes it has to be said. Do not provide legal advice to your client when there is potential trouble on the horizon. So that's the first and most important thing. The second thing is, do not have your client sign a mutual release without obtaining legal advice. Time and time again, we see clients come into our office who have signed a mutual release and not understood the full ramifications of the document that they signed, right? It could be the seller signing a mutual release because they want to get a hold of the deposit, not realizing that they've given away essentially their right to pursue more than the deposit in signing that document. The next thing not to do is do not delay referring your client to a litigation lawyer if there's any trouble on the horizon, right? I know that sometimes clients can get scared or concerned about the cost of engaging another lawyer, but you have to make sure that you refer them as soon as possible to protect their interests and to protect you as well. The next thing to not do is preemptively relist a property where the deal has fallen apart and there's no mutual release signed. I've had at least one client come in to see me where she was the seller. It was a conditional agreement of purchase and sale. The buyer decided to walk away during the conditional period. She relisted the property before they signed a mutual release, went ahead, sold the property to someone else, and then came to see me to say, oh, well, you know, my agent was saying I should perhaps sign a mutual release, but I'm not sure what to do here. And you never want to put your client in a position where they have two agreements for purchase and sale out there on the same property. Because what happened, or what would have happened, if the original buyer then changed their mind and decided that they want to go ahead with the transaction? If your seller client has already committed themselves to another deal, then they're in a position of potentially being sued by one or both of these potential buyers. So never allow your client to relist or sign another agreement for purchase and sale without a signed mutual release. Never coach your client to lie or mislead about anything in the transaction. And this is, I'd say, more when you see things are going south, right? You never want to put yourself in a situation where you're going to court without clean hands, because a judge is a human just like you and I. They're going to see through what you're trying to hide, what your client is trying to mislead. A judge is going to see through all of that. And a good lawyer, a good litigation lawyer worth his or her salt, is going to find the gaps in the case, and they're going to play up on those things that you're trying to hide or mislead. So do not do that. The next thing you shouldn't do is, as much as you can, do not phone up the other side and divulge potentially damaging information in the hopes of smoothing things over. Many times we've seen agents, where a deal is going south, trying to salvage the deal, call up the agent on the other side and say, look, I know you saw that email. My client's going through a nasty divorce. They want to sell this property for X, Y. Just don't do it. Resist the temptation to pick up the phone and divulge information that could be harmful to your client. And the last thing is, please, please, please don't ghost your client and don't ghost their lawyer. As the agent, you will be necessarily called to give evidence potentially, but you certainly will be called by the lawyer to try to figure out what happened, right? What happened in the deal. So please assist your client as much as possible and don't ghost us and don't ghost your client. So that's the end of my presentation. I'm going to open up the floor for questions. I'm sure there'll be tons.
Shaneka, before you open up the floor, maybe you can just go through the questions that are actually in the chat. There's quite a few, starting with Oliver, who had the first one at 10:22. If you want to just read it and then answer, that would be appreciated, and kind of go down that list. It's probably more orderly given that we have 110 people here.
Okay. I'm gonna leave up my screen for a second so people can take down the contact information. And then I'm gonna stop screen sharing in 5 seconds.
I can read it to you if you like, just if it helps, and then you can answer. So
Yes.
what Oliver was asking is, in a market that can be volatile, can a buyer for their protection put a clause that states something to the effect of seller agrees that the buyer's bank will require an appraisal by a professional third party, and if the appraisal is less than the purchase price will be adjusted to the appraisal price on closing. This would likely be crossed off by the seller, but would it be legal?
You can put in whatever clause in your agreement that you want, right? You're negotiating with the other side. Whether a seller will agree to that, I have no idea, but a seller may agree to that. And it's certainly in the interest of your buyer to have a clause like that, but I don't know if a seller will agree to it. If they do, more power to you and all the better for your client. It's not illegal to have such a clause in an agreement, no. And Mark has said this time and time again, like breaching an agreement it's not against the law, right? It's not a crime. It is something that you shouldn't do. And if you do, you're going to be sued for damages or specific performance or whatever the case may be, but it's not illegal to breach an agreement. So I hope that answers the question.
One thing that I have seen done, and it was actually mentioned by Roxana, is I have seen clauses put into agreements that make agreements conditional until such time as an appraisal is done and affirms the price. That is to say,
Yes.
okay, it doesn't reduce the price to the appraisal, but it gives people the option of walking away if the appraisal does not complete at the purchase price. And that is a more palatable option for all sides who are worried about appraisal amounts.
And you can also make your financing condition of a sufficient time that it covers when the appraisal company will come in. Obviously, you have no control over when the bank will send out the appraiser, but if you give yourself enough time in that conditional period, then that should also cover you. And there's nothing to say that you can't extend your financing condition the time of the financing condition, right? You can certainly request it. The seller has no obligation to extend the time, but you can certainly request it.
Just do keep in mind, Shaneka, those are all great points, but do keep in mind, if your agreement is conditional in any way, including on appraisal, I've had this ridiculous circular logic with the banks before. They may very well not send out an appraiser, specifically because it is still conditional, even though it is conditional upon that very appraisal. So it is, sometimes the banks are a bit frustrating to deal with in that regard. For RD asks, if you don't mind, I'm just going to move on because we have quite a few questions. Is there any current case where a judge is going to make a call on a domino effect, making the initial party at fault liable that caused it? Example, the buyer of your property is unable to close, making you short of funds for your purchase. So the consecutive chain reaction is the person who caused the initial breach. Are they responsible for the subsequent damages that fall down the line?
Long and short is no. And the short answer is there's something called privity of contract, which means that only the parties to a contract can be held liable for that contract. So the buyer of your property who didn't close, which caused you not to be able to buy the second property, didn't have a contract with the end party, right? So because there's no connection between those two people, one can't be directly held responsible. What can happen is, as the person who wasn't able to close, I can bring in another party into the suit to say, I wasn't able to close because of this particular person. And there are ways of getting to that, but it's a flow-through process.
Excellent. Linda asks a really interesting question that I'm interested in hearing your response on. She asks if there's a cost threshold to litigate if having to sell for less than the original contract, where it does not make sense to sue for differences. I'm going to amend Linda's question. And then she asks, are litigation costs able to be passed on to the party that breached? If with permission, I'm just going to amend Linda's question to you, Shaneka. Obviously, if it's 35,000 or below, you have small claims where there is access to justice. At what point above $35,000 does it make sense to leave small claims and engage in the non-small claims court process, given the cost of litigation? Linda, I hope you
So
don't mind me amending, but that's
no, no, no.
really the substantive question.
Yeah, so in small claims jurisdiction, I would say, if it's 35 and under, you're perhaps best suited to get a paralegal to deal with that, or a really junior lawyer to deal with that from the cost perspective. When you get past the 35,000 threshold, you're in Superior Court. But even in Superior Court, we have two bands. So claims that are under, I think it's 125,000, are now considered simplified procedure actions, which means that the process can be a bit faster, but there are certain steps that are not permitted in that threshold. And at anything above 125 is regular Superior Court. So to the question of, what does it make sense from a financial perspective, really, that's a question that the client has to answer, because it may not just be about the money for the client in terms of what they're going to be recovering, but also keep in mind, to the second point of Linda's questions, the party that is successful in a lawsuit generally gets to recover a portion of their legal fees. They never get to recover 100 cents on the dollar unless there's a contract which says that they can, and generally in real estate, there is no such contract. But you will typically get to recover what we call partial indemnity costs. And depending on the judge that you're before, partial indemnity can mean many things, but it's usually, I'd say, 50 cents to 75 cents on the dollar that the successful party is able to recover. Does that answer the question, Linda?
Yes, you did. That's perfect. Jane asks.
Excuse me, Mark.
Yeah.
Mark, it's Sandy. I'd like to interject at this point, because I've had a couple of agents message me about a point in the presentation that, while they're all still here, I just want to clear up. Shaneka said, do not preemptively relist the property when you have no signed mutual release. She didn't mean in general. She was referring to a situation where the seller and the buyer agreed to bring the first contract at an end, but the agent never prepared proper paperwork. She's not talking about the general breaches. Can you clear that up, Shaneka, please?
Yes, that is correct. Because one of the things that as a seller, you are obligated to do when there's a breach is mitigate your damages, unless you're looking for specific performance, right? So as I said, everything that I'm saying is general education. Each case will be different. If you're looking for the other party to honor their obligation to you and buy your property or sell their property to you, then you're not going to relist that property because you're asking for specific performance. But if there's no request for specific performance, and as a seller, you have an obligation to mitigate your damages. And in mitigating your damages, one of the things that you do is relist the property, but that's after you've been told by the buyer that they're not going to honor the contract.
Exactly.
If you relist the property and you haven't been told that they're not going to honor the contract, then you're the one in breach as the seller. So yes, thank you for clarifying that, Sandy.
And this is why I can't stress enough to all realtors, in a dicey situation, contact the litigation lawyer and follow their specific instructions. Because if you make an error in your paperwork, it can affect the outcome of the litigation. So don't just go on your own. Even though you're part of this group and even though we teach you, contact the lawyer and follow their written instruction.
And to that end, guys, Jane, I'm just going to give you a one-line answer to your question, and then I'm going to turn back to Shaneka with Katie's question. Jane asks, I understood with anticipatory breach, we could get it back on the market without a mutual release. Jane, that is correct, but just pursuant to what was just said, you need to get your lawyers to give you that permission. Your lawyer will affirm that the paperwork as between the parties is in place and that anticipatory breach has taken effect and will give you permission to relist. So please do not just put it back on the market without getting permission specifically from a lawyer on letterhead that you can do so. Why? Not because the lawyer understands the law better than you, though we kind of hope they do, but rather because the lawyer has insurance. And so when they say to you, go ahead and do this, you are covered yourself. Katie asks, No problem. I hope I didn't go too fast through that one. Shanika, Katie asks, do builders go after buyers who walk away from their deposits? And if the builder sells for more than the original price, is there anything that the buyer can do?
So generally speaking, yes, builders do go after buyers who have breached their agreement and for their deposits. And yes, if a builder sells for more, yes, they, generally speaking, can keep the deposits. The deposit is forfeited.
Okay,
Obviously,
terrific.
there are different instances where there could be exceptions, but the general rule is that, yes.
We have a lot of interest in this topic today, Shanika, so the questions continue. I hope you don't mind if I keep reading them.
No, keep going.
So Ashley asks, as realtors, what can or should we do if the buyer is indicating they may breach the contract, not yet anticipatory, as they haven't actually said they won't be able to close? Obviously, you seek legal advice, but what can we say to make it very clear that they are indicating to us that they sound like they're about to breach and maybe scare them into not breaching?
So what you should not ever do is contact the other side to say, hey, my clients told me this, there may be trouble on the horizon. You should definitely be directing them to speak to their lawyer about whatever issues arising. And to the extent that you can assist them in getting back on track to getting the deal closed, obviously you do that. But I never communicate that to anyone other than your client's lawyer.
Okay. Thomas asks, banks now do secondary appraisals before closing. How can you protect yourself against a secondary appraisal? And I think implicit in what he's asking is what happens if you have an appraisal, you're good to go, and then a secondary appraisal comes out, it's below the original appraisal, and you find yourself with a shortfall disallowing you from being able to close. How do you protect yourself against that situation?
Go find the money somewhere.
There
That's
you
a short
go.
answer.
Good answer. Okay. Let's go to Jack. Jack asks, when is it appropriate to relist the property sold firm unconditionally without a signed mutual release?
When the seller has indicated in writing that they cannot close or are seeking an abatement or seeking to change the terms of the agreement, and it is clear that they will not be closing on closing date.
You said
again,
seller, but I think you meant buyer there, right?
Sorry, buyer. But again, back to Mark's point, make sure that they speak to the buyer speaks to their lawyer, the seller speaks to their lawyer, everybody speak to your lawyer before you relist the property.
Okay.
If I can interject on that, agents need to understand that anticipatory breach only exists when certain language threshold is met. Someone saying, I don't think I can close is not anticipatory breach. And this is why agents need to contact a lawyer, is because there are specific words that need to be said lawyer to lawyer before it can be called anticipatory. And cases have been overturned on even lawyers using the wrong words. So this is why it's crucial to contact the lawyer. You can't just say, well, they said they're not going to close. They may not have used the proper language. You can't determine that.
Okay, I'm going to, thanks, Sandy. I'm going to move on to Gladys. Gladys asks, what happens if a builder is trying to close on a development with the buyers and there's new damage on the common elements? Would the buyer be required to close on that deal? Also, if the workmanship on the building is poor and have had multiple problems, is there something that the buyers could do as a group to make the builder liable for it in the future?
Sounds very specific, but generally speaking, going back to my point about conditions versus warranties, right? If the breach goes to a fundamental aspect of the agreement, which goes to the heart of the contract, then there may be sufficient element there to walk away from the contract. But if it goes to a non-essential term of the agreement, And to me, something dealing with the common elements may be something that is covered under a warranty. Then the buyer may have to close and deal with the builder after the fact for damages to deal with whatever change needs to be made to the common elements. Would the buyer be required to close on that deal? So generally speaking, I would say, again, it depends on the facts, but if it's something that does not go to the heart of the contract, then yes, they will be required to close.
If I may just pipe in as well with one other fact here, particularly with new build development, you also have to introduce Tarion and the concepts of Tarion, because of
Yep.
course what Tarion does is it ensures that builders are going to build to Ontario Building Code standard. And because there is the Ontario government that is backstopping that, it is acceptable to close with deficiencies, even though it is new build, with the assurance that it will be brought up to speed, because that's what the contracts effectively say, that there will be 6 months to bring this up to speed and up to the standard of Ontario Building Code, else the province will step in. So do keep in mind that, particularly with new builds, there is an additional factor in the form of Tarion that must be considered that often force people into a situation where they close with deficiencies and have to just deal through the normalized process of new construction. Okay, so Sanchita asks, do you want to read them? I think you're caught up now.
Sure.
If
So
you'd like to, please.
In an anticipatory breach, is the seller simply telling the defaulting party that they're considering, is a lawyer simply telling the defaulting party they're considering this agreement defaulted based on anticipatory breach, and then can it be relisted? So usually in anticipatory breach, the buyer, either through their agent or themselves or through their lawyer, will say, you know, we can't get financing. Let's use that as an example. So we won't be able to close on closing date unless you give us an abatement or whatever the case may be, right? In that instance, if they've used the language to make it clear that they will not be closing on closing date, then yes, the seller can go ahead and relist the property. If the seller wants to wait until closing to relist the property, I think that's a good move. But in some instances, it could be weeks before the closing date, and the seller wants to get ahead of the market, get ahead of the closing date to try to get someone in the property before. Really depends, but yes, if the appropriate language is used to make it clear that the seller does not have the intention to close on closing date, then yes, the property can be relisted at that time.
If I may jump in for 1 second, Shaneka, and not to in any way contradict anything you're saying. Sanchita herself is a lawyer, and I would just tell you, Sanchita, one of the ways I protect myself as a lawyer when I am stating that it is anticipatory breach is I state, here is the correspondence you've sent. This is anticipatory breach. You have until tomorrow at 5 p.m. to disaffirm this, failing which I will assume that that is the state of affairs and shall be proceeding to relist. In other words, I do, as a matter of course in my practice, give knowledge of the fact that I'm treating it as anticipatory breach and give them a time to correct and communicate with me to say it is not, in the anticipation that it may eventually end up in court, and there will be correspondence from me to them which stands as uncorrected, which I think puts my clients in a better position should that happen. So just as a matter of practical principle, that's the way I deal with it.
And that's a great practice, Mark, and I think all the real estate lawyers in the group should adopt that. But then there are cases where it is very clear, based on the wording of the lawyer's letter, that they're not going to close. So yes, if you want to give them that out, I would say, to get back to you and let you know for sure that they're not going to close, I think that is really good practice. Yes.
You're on a roll, Shaneka. Continue. This is fascinating for everyone.
That was the
Please
last one. Following up on my previous question. Is there any current case where a judge is going to make a call on I think we answered that one, on a domino effect? Is there any way to tie the first buyer to yes, I think we answered that one. and I don't see any more.
So let's
Did I
turn our
miss any?
attention. We have 3 more minutes or so. So anyone who wants to pipe in with a question and demute themselves and ask, Shaneka's at your attention.
Hi, Shaneka and Mark. Thank you everyone for this awesome presentation. Just to follow up with my question, I obviously didn't write it properly. So my question was what I was trying to say or ask, if there is anticipatory breach or it's not yet anticipatory, but the buyer is indicating they might not be closing and I'm acting for the seller, what should we do as the seller's realtor to say, hey, this is not looking good. You need to talk to your buyer client and make sure your buyer client figures it out, gets private financing, whatever. Like, what can we say or what should we do? Obviously getting legal advice because the anticipatory breach might be coming down the pike, but what can we do in the meantime?
Well, so your question is, the buyer's agent has communicated to you, the seller's agent, that, look, they may not close, right?
Exactly. Yeah. And I'm acting for the seller. So I have had this happen. My deals ended up closing, but obviously, you know, the world today. So
Yeah.
what do we do as sellers?
So the first thing that I would do, Ashley, is I would say to that buyer's agent, have your client communicate with their lawyer and put that in writing through the lawyers that they're not going to close. Right. And if they say, well, you know, I don't know if they're going to do that, I don't want to do that, then have them communicate that to you in writing. Then you, as the seller's agent, flip that to your client's lawyer to say, this is what I've been told, this is what's been communicated to me. Or even if they don't send it to you in writing, have your client contact their lawyer to say, this is what my agents told me is potentially going to happen. Can you reach out to the buyer's lawyer? If they have a lawyer, if they don't have a lawyer, can you reach out to the buyer's agent to confirm this information? Because you want to confirm it before you go ahead and take any steps, right? If you don't get that confirmation, then you're potentially running the risk of, as I talked about before, putting the property on the market and potentially selling it to someone else before that other person has affirmed that they're not going to go through. And there's a recent case that talks about this very instance, and the court had to, you know, dissect the language of each party to say, well, did they mean this? Did they mean that? Did the seller put the property on the market too soon? And in that particular case, the judge found that it was reasonable for the seller to have put the property on the market, but you don't want to have to go through that dissection of, you know, did they mean this? Did they mean that? So just make everything as clear as possible.
Amazing. Thank you.
All right. So Shaneka, I hope you don't mind if I bring this to a close, unless you'd like to continue to stay behind and just answer some more questions if people have them. But I think just for
I
the
see
purposes.
Wesley has his hand up.
Oh,
was gonna
Wesley,
say
well,
something.
you always allow Wesley to speak. It's
That's
a
right.
rule in law.
That's
Isn't
right.
it, Wes?
I'll speak to the people who stay past 11. I just have a couple of comments that I think are important.
All right, so let me just say thank you, and then I'll keep it going so that people can continue the dialogue. Guys, there is a reason expertise matters. You see it in Shaneka, you see it in Wes, who's piped in at the last moment. See, Wes, by saying that, you get included in the whole hullabaloo. But you do see it in the litigators that we have on our forum. I am incredibly grateful to Shaneka's experience. I'm incredibly grateful for her time. And for her willingness to help out those people who need help. And that is true of almost every file that I have sent her to date. I would encourage you guys to use the lawyers on this forum as resources. They are vetted, they are known, and they are great. Shaneka, thank you for your time. Thank you for everything. Really appreciate it. I'm going to take the recording off, and then I'm just going to let this go for as long as anyone wants to hang around, which is a new thing we're doing here at the forum, apparently, but it's happening. Here we go.